Welcome, and it's my pleasure to introduce briefly Eser, who comes to us from the University of Chicago. He's a PhD, SJD student working on his dissertation on the topic of South Carolina's dram shop liability regime and its effect on insurance and a lot of other things. And he's got a lot of interesting things to say. Hope you have a chance to read the paper. If you didn't, anyway, he's going to summarize his talk, and we'll do that for 20 to 30 minutes, and then I will keep the queue. So just raise your hand or send a chat to me. And Eserhan, welcome. Thank you very much. And the floor is yours.
Uh, Thank you so much for introducing me, Peter. And nice to meet you, everyone. My research is on mandatory insurance, which is often taught as a tool for victim compensation to ensure the collectability, solvency of potential tortfeasors are there for the victims. But my research suggests that it does something more. It creates an informational awareness among the victims so that they claim more. In 2017, when South Carolina make the liquor liability insurance mandatory, most businesses had already insurance, yet the claims surged a lot. Check the accident data, it stayed the same. I checked the alcohol consumption data, it stayed the same. I checked the market extent, it stayed the same, but claims surge. So it suggests that this has more of an informational effect among the potential tort victims. So let's take a step back and bear with me for a second. I will put my slides up.
Great.
Here, see it? Okay. So dram shop liability, it is the legal doctrine that holds alcohol vendors liable for injuries that are caused by the patrons. So in a typical scenario, the bar customer goes to a bar, gets drunk, and then does drunk driving, gets into an accident, do some damages, and the victim to the bar. And dram is the term, an archaic term for alcohol served in small shots, and dram shop is coming from liquor serving by the drink term. In South Carolina, dram shop liability is anchored by the 2010 decision. And for this project, the underlying dram shop liability rule is stable during my study window. So there's no change of the liability in between 2010 to 2025. In 2024, a police officer got into an accident, and he got injured, and they tried to sue the bar. They tried to sue the driver, and none of them had insurance. So the city had to pay for the damages, and then the state made liquor liability insurance mandatory starting July 1st, 2017. And then the law itself requires all establishments selling alcohol for on-premise consumption carry liquor liability insurance, and then ensure, there were two goals: to make sure the victims have compensation and make sure the businesses internalize the damages so that it reduces the accidents. They act responsibly. After a few years, the insurance premiums started to go up, and it reached a point in 2025 that insurance companies, even with the increased premiums, they started to leave the market. And once they left, they started to leave the market, turned into a crisis. So South Carolina State established a few commissions to examine what's going on, did hearings at the Senate, and fast forward this year, they not only softened the rules of insurance, but also soften the rules of liability for liquor-related harms. So my starting point was drum shop liability, because I thought the issue, the action, the decision between serving alcohol and drunk driving is too distant. So the liability might work for victim compensation, but wouldn't work for deterrence effect. So even if there's a strong liability there, the deterrence wouldn't change because these are two separate, unrelated actions. And then I tested that with after and before 2010 decision, and there wasn't any change in accidents. And then I tested that with 2017 liquor liability mandate, insurance mandate, and there isn't any change in the accidents. So, but the thing is, the premiums are going up, and this doesn't reflect the reality on the market that insurance companies are leaving the market. Imagine the state makes mandatory for insurance companies to sell products that people have to buy your product, but you leave the market. It doesn't make any sense, and it doesn't make any sense, especially there isn't any change in accidents. So to analyze what's going on, I created a original data set, got the insurance data from Department of Insurance of South Carolina, got the accident data from Department of Public Safety, got the license data from Department of Revenue, and got the ethanol consumption data from National Institute on Abuse and Alcoholism. I also did a lot of interviews with bartenders, bar owners, insurance brokers, insurance underwriters, plaintiffs' attorneys, defense attorneys, and some of the people in South Carolina State Commission for that insurance investigation, here me in South Carolina. And then the main finding is this figure 1 of my study. This is unmanipulated data, raw data. On y-axis, it shows the claims number. On x-axis, it shows the accident year. And this is the same plot, but it shows the percent change, year-over-year percent change. So from 2014 to 2015, there is not much change. But in 2016, you see there is 150%. There is more than 100% increase, jump here. But interestingly, the law was in effect July 1st of 2017. So this is not directly related to insurance expansion. This shouldn't be directly related to insurance expansion. And it is more similar for an information spillover to the 2016, especially if you think that all this coverage and then this law is introduced in 2016 also. So it showed that the testimonies and the initial interviews I conducted suggested that most people had insurance before the law. Most bars had liquor liability insurance before the law. But I also wanted to verify that with the policy data. And this is year-over-year change in written policies. And this shows the growth rate. If you see that this chart, from 2014 to 2018, the market growth is stable, 15% a year. And especially there isn't any hike in 2016 and 2017 that can justify the claims hike that we see in the claims data. More importantly, you see after 2019, the insurance market started to shrink for 2 years, probably rise costs. And after the COVID, this might be due to COVID, and after the COVID goes away, it's went up a little bit and then also shrink again. So for this study, there isn't any jump in 2016 or 2017. So I did a lot of robustness checks, way more than I'm going to present right now, but not all of them are in this paper. I wrote several papers for features. So the first thing I checked is there an accident search or not? And this is also raw data, no manipulation. On y-axis, it shows the count. On x-axis, it shows the year. And for every year, you see it is a pretty flat line, especially there is no hike in 2016 or 2017 that can justify the claims, 115% claims hike in 2016. And another thing I checked was an industry boom. So this is the license data. This is not the raw data that I got from them. I did some data manipulations. On x-axis, it shows every dot is a day. On y-axis, it shows the active license number on that day. You see, this is where the law change happens. There is no hike. It is pretty flat line. And there is not an industry boom in 2016 or 17. Then I checked, maybe South Carolina became more drunk. I mean, everything stayed the same, but they drink more. But you see that there isn't any change in alcohol consumption per capita. There's a slight increase in total consumption, but also it doesn't justify the jump. It's like an opposite of this hike. So this brings us to the theory. So the traditional standard view of mandatory insurance, it gives you coverage and it spreads the risks. And states usually do mandatory insurance because in a typical adverse selection market, that people who stay outside of the insurance coverage have lower risks. So when you do mandatory insurance, it reduces the insurance premiums because it reduces the overall risk. But here, the effect is just the opposite. When there is mandatory insurance, claims increase and then premiums increase. So I suggest that the information mechanism puts insurance companies in the target for plaintiff's attorneys, just like puts them in the middle of the bullseye and identify the market, signals them, go sue them and get your money. It has implications for serious implications for insurance economics because traditional insurance economics overlooks the information value. As we see here, insurance companies every year lost $2 for every $1 they insured during that period. So they couldn't price that information value in their pricing models to adjust the premiums. Be aware that there is no pricing controls for liquor liability insurance. And because so many companies are leaving the market, the Insurance Commission is also trying to invite companies to come to liquor policies here, and we will allow so much flexibility with pricing, yet because they cannot price this information value, stayed out of the South Carolina liquor liability market. This research has also implications for access to justice. It clearly shows that access to remedies is governed as much as by information flows and by formal legal rights. So you may think that once there's a mandate, this information moves genuine victims and allows genuine victims to compensation, but also you may also think that it facilitates rent seeking by attorneys. I mean, my data so far doesn't allow which way. It suggests that this is a genuine victim compensation, genuine release of latent claims, but I can't really fully tell that this is not attorneys running after rent. And if you ask from the insurance lobbyists, they would say that, oh, this is an attorney-induced crisis. And this research has several implications for the deterrence theory, but the most important one, deterrence models usually assume the perfect information when the plaintiffs are deciding whether to claim or not. But this research shows that there is an information aspect of it, and disclosure rules might be potent instruments for the accident law. And when they are calibrated carefully, they can create a lot of benefits, or depending on your size, hazards for the market and for the deterrence. And similarly, there are some policy implications. I think the most important one is the cost assessment must incorporate the plaintiff responses. Because if you don't know how the plaintiff responses are going to explode, then you may break the market just like South Carolina regulation did. And it should also recognize equity dimensions. I cannot tell with the data that I am looking whether this increase, it should match with they should look at the welfare implication, whether this helped more to attorneys or whether they helped more with the victims. And also, the policies must coordinate with the market instead of this sharp discontinuities, which is great for research. Thank you, South Carolina. But it is bad for the market, and because then you see there are very adverse effects of it. So future research directions. I think the first thing and the future research focus is generalizability of this study. I here examine one insurance and one state. So first thing you can say is the people in South Carolina are weird and behave weirdly. In Connecticut or in Illinois, people would behave differently, which is likely but possible. But the more important generalizability question is whether this effect is function of liquor liability insurance line. So liquor liability is a sui generis situation. It may be different when there is professional mandatory insurance, professional liability insurance, or just driving insurance. So the research is on that. The second thing is behavioral data. I can't really figure out, I know that this is an information effect, but I can't really figure with my data set whether it stemmed from attorneys or victims. For example, this law might create an advertisement effect across the society. So victims came out more to find the attorneys, or this created an awareness among the attorneys, and they started to take more cases, or both of them working at the same time. So my data set doesn't allow to distinguish, and I think it is really important to distinguish what the real cause. And welfare analysis is also another aspect. If you talk with the insurance industry or borrowers, they would say that this is for attorneys are getting richer, which may be true, but it has also shown that more people are accessing to justice. So a welfare analysis is necessary. My data set doesn't allow to analyze that. Political economy. So one alternative explanation of what I see here, and which is less likely but still possible, is that attorney plaintiff's bar discovered this 2016, and they changed the law. So it's like a reverse causation. They changed the law. So oh, here there's gold. So let's make it a $1 million minimum coverage, and let's make everybody has to buy it so we can get more money. That might happen also, but if you talk with again insurance lobbyists, they would say that is the reason, but I am not sure with the data set I have. And another issue I think really interesting is the substitution effect. So one thing I encounter is there are interesting bargains are happening. So when plaintiff's attorney discovers that the person, the drunk driver, got drunk in a bar, they immediately become friendlier towards the driver to get the information about the bar. Because if he drink more than one bar, like 5 bars, and it automatically increases the potential recovery, then there's like 5 insurance policies out there. So especially if there is a waiver of subrogation in the policies of those bars. So then the attorney settles with the drunk driver, get the information, and then go after the bars with those information. So I think that should see that substitution in the driving insurance data and then the claims towards that. But I don't have that data set, so I can't verify this result. But I think this is an important fact, and it has also implications because the regulators, like right now, if you get into a drunk driving accident, you can't discharge your debt even with bankruptcy. So the state making you responsible for the debt you caused so that it creates deterrence. But if you allow drunk drivers to get rid of the debt with this information bargaining effect, with this insurance bargaining effect, then your measures of deterrence wouldn't work, and especially wouldn't work on the person who has more control on the behavior as drunk driver than a distant alcohol serving body. So this is the insurance workshop. I thought I can get benefit from you by asking questions to you. And my questions are, the first one is, where do you think I can observe a similar phenomenon? Which means, do you think this would show or like observe an opposite phenomenon in a professional malpractice insurance or our driving insurance, or where do you think I can observe this? And then the second thing, how do you think information mechanism really works? Do you think that it is working with the attorneys taking more cases? Because when I first pitched this idea to prominent scholars, one of them told me that attorneys are super sophisticated, and why they didn't uncover this, it is a question to me. So does this information mechanism, if the information mechanism work on the people, then this makes sense. But if works on the attorney side, it is still puzzling because as a sophisticated parties, they should have already uncovered that part. Thank you for listening. That's all I can present.
That's not all you can present. There's a lot more you already told us about, and I'm sure we'll get to that in the questions. So let me open the floor if anybody wants to raise your hand or chat to me. Maybe I'll start with just where you left off there. So it seems like the story that you're telling has to be a kind of disequilibrium story where, okay, I see Omri's next, where somehow plaintiff's lawyers just didn't realize that 90% of the bars already had coverage, and or maybe they just didn't even realize that, hey, there's bars that you could sue in the first place somehow, and then it was the mandate that you characterize as informing them. But is it really information? I mean, there's just not that much information being conveyed by this, because unless you're starting from a blank slate and you thought, oh my gosh, there's no point in suing bars. Joe's bars is not going to be, they're going to be just as judgment proof as the driver who ran into my client. There's just, what you really should learn if you were in equilibrium before is that there's a 10% greater chance that 11% greater chance that the bar that caused this accident or contributed to it has insurance. 100% versus 90%. So, like, if you just did the math on that, it just doesn't seem like there's enough oomph. There's just not enough extra information conveyed there, because if you're Bayesian about this, you would say, well, there was a 90% chance before, there's a 100% chance now. So I haven't really learned that much, unless what you're thinking of as information is kind of psychological, like, oh my God, it never occurred to me. I guess now I should think about this. Is that your story? Basically, there was just a disequilibrium where the plaintiff's lawyers, they had their boilerplate language and the complaint about who they were going to sue, and it never occurred to them that, oh, they could sue somebody else. And now it's like, oh, bing, light goes on, and everybody's now suing bars, so I might as well do that too. Is that kind of the story you have in mind?
So I have the exact same dilemma with you. I had the exact same dilemma with you. And what I try to do to disprove everything else, like whatever the alternative hypotheses were, I try to disprove that, because I also thought that attorneys are super sophisticated. They would know it. And then if you think about the chances of taking a case or not. But when I was interviewing plaintiffs' attorneys, the sophistication level isn't that stable. So some attorneys might just dismiss the case, assuming that that small bar, that small corner neighborhood bar, wouldn't have the insurance, and they wouldn't take, because it's not worth for them to take the case. Think of the contingency fee attorney perspective. Every time you take a case, you are doing an investment decision by looking at the collectability, by looking at the loss. So I am really not sure how this information affected. It might be, it makes sense. It also makes sense if it created advertisement effect on the potential victims to come out more, because how would the victim, I mean, if the victim knows that they can sue more people and they only go after the drivers and they settle with them, but after a while sees in the news that there's like now bars requires insurance, and then they go to the attorney and then it increases the claims. I can't really distinguish. I know I can't find any alternative explanation to explain this chart, but if you have some other alternative explanation, I am to take it.
Great. So let me just quickly jump in to say that there's a bunch of stuff, and I'll send you some sites, that there's a lot of really terrible plaintiffs' attorneys out there, and they routinely do really, really, really bad work. Like, I teach employment discrimination, where the plaintiff's bar is just often shabby. There's some great ones too. And there's hard evidence that they just leave money lying on the table all over the place. So I'll send you some sites on that. It's not crazy to think that that's what's going on. All right, so the queue is Omri, Mark Meyerson, and then Travis, and anybody else who wants to jump in. Omri, welcome, thanks. And
hi, good to see you, Eserhan. One thing that's going on here is that there are two insurers, right? The drivers have insurance, and then there is the dram shop. And usually when there's a drunk driving, there is a claim against the driver's insurance. But I think that probably possibly what's going on here is that auto insurance liability is very low, let's say $50,000 at best in many of these cases. And so I wonder if the channel for information flow is through the insurer. The auto insurer alerts the claimant, hey, there is another source here that'll give you $1 million. So it's not exactly advertising, it's not exactly knowing the law, it's more specific to this particular context when you have two insurers. And while there is, issues of coordination of benefits and all that, I would imagine that it kind of, given the money that you can get and the full indemnification you can get from the bar insurer, there's no point to go after the auto insurer, which creates this incentive for the auto insurer to channel or to inform the claimant, don't go after us, go where the money is.
That's a great question. It may be possible, but then I would think that we could have seen this before the law. So what changed? I mean, insurance companies would know that bars had the insurance. So I would think that if they are alerting, they should have alerted before.
Yeah, I think that you're right that the timing doesn't really square off, but I think it just seems so plausible to me that when all of a sudden there is a new insurance and there's another $1 million, available somewhere, that this would be a channel. Since you're interested in the general framework, I would wonder how, maybe a productive place to look is on the coordination across insurers or the deflection here from one insurer to another. But that's just a suggestion. You're right, it doesn't fit with the data.
Yeah, I will definitely check that.
Okay, Mark Myerson, you're up next.
Hi, I really enjoyed your paper. This is also a topic that if one reads the daily insurance news, one has been seeing this make news stories on a regular basis. And I really think your concepts about substitution effects is really fascinating. But I think the key is, has just been hinted at, which is that it's the amount of coverage, not the fact of coverage. It's that it's $1 million, as I believe your paper says the statute requires. And that's what I think is the distorting effect and the new information. Because comparing it to auto, drivers have insurance in theory, right? But they only have $50,000 of insurance. $1 million, changes the game dramatically, because I'm just positing the injuries and the medical expenses are all constant, and pain and suffering, but victims routinely are undercompensated. So now we're in a situation where we know that plausible defendants have not just assets, but they have $1 million of insurance money rather than blood money that's available. So if we compare this to Bernard Black and his group's study of the Texas malpractice system, where they talk about how doctors reduce the amount of there's kind of almost the argument is that doctors reduce the amount of the limits of the coverage they purchase to the point that plaintiffs won't seek to jump around the insurance and get to their personal assets. And and this becomes downward pressure on the net compensation to victims, and doctors then have the incentive to reduce the amount of limits they're carrying. But those doctors, at least as I recall, the book is Medical Malpractice Litigation by Professor Black and his group. I think the coverage that the doctors had was less than $1 million, at least as I recall. And so to me, once you have $1 million, then the attorneys have an incentive to advertise and mine and solicit these kinds of claims. And it becomes worthwhile for attorneys to be involved at all. And this all becomes this cycle. But if the numbers were mandatory insurance limits were $100,000, then the economics of practicing law doesn't work the same way. So it's not that as Peter suggested earlier, the existence of insurance, because you can kind of hypothesize that any reputable business has insurance, but rather, hey, I know this is $1 million of ready dollars, and to me, that's the distorting effect that you've really put your finger on here.
That is great contribution. So my first thought was, and so Omri's first thought, and he's my advisor. Our first thought was it is a deep pocket effect because now when you put $1 million insurance, then people are going after more. But the research, the data here points out the effect is ex ante. So it's like 2006, in 2016, they didn't have $1 million. But what you are saying is because now there is 1 million insurance effect, the attorneys are advertising more. And because of those advertisements, people are coming out more and there are more claims. Yeah, that is a possible explanation. Thank you.
Travis.
Great. So, fascinating paper, and I wasn't that familiar with the story, although the interface between this narrative and the Murdaugh stories is anyway, I guess not surprising, but remarkable. So, I I wonder whether there's a little bit more granular story to be told, and perhaps it's not relevant to your particular research question, but about the way that the insurance companies responded to this requirement by tweaking the terms of coverage in ways that allowed the coverage to continue to satisfy the mandate, but actually constrained it in sort of more subtle ways. So and like I just did a little bit of like Googling and things, and my understanding is that, for example, the statute said that the dram shops had to purchase coverage with $1 million worth of coverage, but it was ambiguous as to whether that meant the aggregate or the per occurrence. And so what the insurers did is they started selling coverage that had $1 million in the aggregate, but very low per occurrence limits. And I think that it seems like there's been some more recent legislation to kind of clarify that. And then I on first principles, I could imagine the insurers sort of switching, perhaps, I don't know, like switching from occurrence-based coverage to claims-made policies, and that having some kind of interesting effects on, I don't know, like, that changes the value of the coverage in interesting ways. And then, if these types of changes are rational changes for the insurance companies to make under these types of market conditions, you would imagine the lawyers responding in some similarly rational way. And it just seems like there's a sort of like story you could tell about how, when you do this kind of mandate in a clumsy way, the way South Carolina did, like how that plays out. And I'm just wondering whether you got any data about that, perhaps from your interviews or otherwise.
So the data, I didn't check whether the occurrence limits. I have seen that they give $1 million limit, because even though it is not highly regulated, Department of Insurance and Department of Revenue was following those policies. So one interesting thing, nothing in the statute says this should be occurrence policy or this should be claims-based policy. I mean, the results might be super different depending on the situation. And the wording, the law says this should implies that it should be occurrence policy, because as long as you have the license, you should have the policy so that it should cover the amount of time you were serving alcohol. But it doesn't say explicitly about whether it should be a claims-based policy. Yet the policies that I can get my hands on, they were all occurrence-based policies, and there weren't any limitations. I mean, maybe I'm remembering wrong, but there weren't any limitations per occurrence. I don't know why. I mean, you would expect insurance companies do that, but they reacted so late. Like by the time they started reacting, the market is super unstable, and instead of trying to tweak the policy, I guess this is a market that doesn't justify this much effort. They just left the market instead of losing money. I mean, but I'm going to look at more about whether there's more story or why they haven't changed the policies. I mean, for me, the crazy part is why they couldn't price it. But I can tell with the data I have right now.
Okay, so the queue is Ethan and then Ian. Ethan, you're on.
Hey, good talk. I really enjoyed it. My name is Ethan Jedziniak. I did a lot of research on this recently, and ironically, I'm a lawyer in South Carolina. I started out as a plaintiff's lawyer. Dram Shop bought my first house, candidly, and now I'm a defense lawyer, and I do Dram Shop defense.
Perfect candidate. I should add you in my interview list.
One of the things I know that was pretty popular down here was when the department was releasing their numbers on the market and insurers in the market. The director kind of said that they weren't including surplus lines insurers on their data. They were only including domestic or regulated insurers in that data. Do you have any idea? Because when we see these policies, right, like I think Liberty is pretty big here, Travelers is pretty big, but for the most part, you're getting these surplus lines companies that are based out of Utah or somewhere weird that really have no relationship with South Carolina. Do you know sort of the breakdown of what these policies are in terms of whether they're all surplus lines, like 80% surplus lines? How many of those surplus lines insurers are actually writing these liquor liability policies?
Like with surplus lines, do you mean the insurance companies that are not registered to South Carolina and working somewhere else and then selling through the broker? Or do you mean that one?
Yeah.
So at first, like from 2017 to maybe 2024, most of them are state registered companies. So they left in 2024 and in 2025, and they left altogether because I think maybe the pricing models that they were using were, I don't know, shared with each other, but they decided that it is not profitable, and then they left together, which was more interesting to me. And there's no data of these unregistered companies selling through the broker. So the insurance data, maybe I should also clarify that, is compiled by South Carolina's Department of Insurance data call to the companies that are registered in South Carolina. And then they delivered the data, and then the data was problematic. They did another data call, and then they compiled this data. So technically, they should have gotten out-of-state insurers because those insurers can only sell liquor liability policy if they are working with a licensed broker in South Carolina. So it is possible to ask the brokers and collect that data, but that data was never collected. So I can't say that. But especially for the hike, when it is happening and when market is shrinking, it is maybe 90% of the market.
Great. We have Ian Russell and then Barry D. I don't know your last name, Barry.
Right. Yeah. Hi. My name's Ian. I'm a law student at UConn here in the insurance law seminar. And so I'm speaking mostly from my 1 year of experience working at a plaintiff's firm. So take that with all applicable grains of salt. But one thing occurs to me as we're talking about this kind of information mechanism is that civil defendants are not always very forthcoming about whether they have insurance at all or how much it covers or what it covers. And so finding out whether there is insurance even if you know there probably is insurance, and even if, in this kind of pre-mandate era that 90% of the bars had insurance, could be challenging. And it occurs to me that even if the difference is between 90% and 100%, it's also a difference in terms of how much the defendant can hide the ball and how difficult that makes it to litigate the case. Did anything along those lines come up in your conversations with plaintiffs' lawyers or defense lawyers for that matter?
Yes, and I asked a similar question, but the thing is, the disclosure rules require that you should disclose the insurance once you file the suit. So if you don't file the lawsuit, then they don't have any requirement to disclose the information effect. But once you file the suit, and it costs $50 to file that, I don't know, maybe some effort to compile the claim. But I think the effect more of when they are taking the case or not, they might be not taking the case, assuming they don't have the insurance, because once you take the case, it's only $50 to reveal whether they have insurance or not. But this is all theory. I don't know for sure how this is happening. I mean, people suggested, but you can't get this type of information from plaintiff's lawyers. I mean, maybe you can, but I assumed I couldn't.
Okay, Barry D.
Yes, sir. Daniel Barry. Sorry, it's my last name. No worries. So yeah, you mentioned the surplus lines issue and trying to find those policies. In a lot of states, I think about 15 states, there are stamping offices, and they usually have information on all the policies that they stamp. That's how they pay the premium tax there. I've been looking, I can't find a South Carolina stamping office, so they might not have one. But the WSIA is the Trade Association for Surplus Lines Brokers. A lot of times they have useful ways to find that kind of information. They can at least tell you the right people in the South Carolina DOI to contact to get that information if the DOI has it. Because, I hear you, it's hard to get surplus lines data a lot of the time. And the surplus lines brokers are the ones responsible for information, and they're not the best source, but that might be something helpful to try to find some of that surplus lines information.
Yeah, thank you so much. I will definitely check it out. I mean, the research process, this project worked as I am doing a private investigation, more like a detective work. And I talk with one person, they give me, some kind of that information that is useful. Then I go there, I get some more information, and then this happens. But I will definitely check this out. Thank you so much. And if anyone else has any idea that where I can get more data or what other industry, and even if you don't remember me, my email is my name @uchicago.edu.
Okay, Walter, you are next in the queue.
Can you hear me now? I just had a question, really not about the plaintiff's lawyers, but about the plaintiffs and how they think about this. If you live in a state where there have been a number of accidents on highways which have caused death, so the family of the deceased has a different approach to all of this. They just want to attack wherever they can, criminally, through liability, get the bar, get everybody. Have you thought about the psychology of what goes on in this, or is it just up to the attorneys?
I have the same question. I don't really know. I mean, I am assuming it may be that there might be plausible explanations why this is victims, like normal people, or why they are attorneys. But the data I have really clarifies this spectrum. I'm working on a project that might uncover that, but I don't know yet. Too early for me to tell.
Well, thank you, and thank you for fantastic slides. I love the graphics. They were wonderful. Thank you.
Thank you so much.
Okay, anybody else on the queue? I don't see.
There are some questions in the chat, I guess.
Yeah, sure. If you want to look at those and you feel like answering them, by all means.
Excuse me, I don't know how to raise my hand, but I just did want to suggest in response to the previous comment. Nora Freeman Engstrom at Stanford has done a lot of work on what plaintiffs want. And a lot of what they want is to prevent it from happening, what happened to them, to happen in the future. You might get in touch with her. Her name is Nora Freeman Engstrom, Engstrom. She's got 2 papers, not yet published, about this effect and how plaintiffs' lawyers work not only to get money, but to get reform and prevent it from occurring again. I think you might find that useful.
Okay, thank you so much. I will definitely check that.
And if I can just put in a plug, Nora Engstrom, will be speaking in this very series in a month or so.
You all want to show up for that. She is phenomenal.
Yep, I agree.
Before we continue,
So,
there are a few other great questions in the chat, but for anyone who's interested in getting CLE credit in the state of Connecticut for this, I put the form and the code in there. And if anyone wishes we were offering CLE credit in some other state, perhaps the state where you're admitted to the bar, there's a form in there where you can let us know. We're kind of working on developing that up piecemeal, and so whichever state we get the most demand for is the next one we'll get accredited in.
So one of the questions was how many of 6,000 bars had liability insurance coverage before and after? It is around 5,600, and it stayed similar. So what that license data doesn't show exactly how many of them are actually selling alcohol. It shows how many active licenses per day. And there are some places at a given time, one company closed their business, but they already had 2 years of license. And then another started at the same place. So there are 2 active licenses at that location. I can tell that the market is, I can assume that the highest limit is 6,000, but I wouldn't know which one of them are actually selling alcohol at that time. So that's why I didn't tell a precise prediction whether it's 95%, 85%, but it is definitely somewhere higher than 85%, as the data points out. And then another question was, do you know if any of law firms suing in these cases received external financing from hedge funds for litigation? Were there any nuclear verdicts, 1 million or more? External financing is what happened in the same time and frame as your study. So with the external financing, I don't know. I don't have any idea. It doesn't seem like they have it with the interviews, but I will take a note and ask that starting to Ethan when I ask for an interview later, and then I can tell you once I learn about it. And then the second question about the nuclear verdicts, yes, but not like 1 billion. There were 17 million ones, 8 million ones, but they were nuclear verdicts before also. So there wasn't, it doesn't seem that change. I don't have the granular claims data to show the median, and I only know the mean of the data, and the mean also didn't change during the study period.
That's the mean award, size.
Yes, mean claim size.
Claim size, sorry.
In addition to traditional insurance, there was a risk retention group, drum shop insurance, drum shop insurer. I don't know what that means actually.
That was Mark. If you want to come back in and explain.
Sure. We had just a second. I'll turn my camera back. You talked about the admitted market, the excess and surplus lines market. I know from a decade ago, there was a specialty insurer that was a dram shop insurer or entertainment nightclub insurer. And it was organized pursuant to this federal law called, and it was a risk retention group. So what the reason I mention it is twofold. One, there that was a type of insurance solution and it issued quote real policies. But the second is there might be a data hole from trying to find if there were a risk retention group, you might not have access to any data associated with that, even less so than excess and surplus lines generally. But it was in response to general market failures for dram shops that this risk retention group was created. It's no longer in business. It's a long story, but that's a different, unrelated to the merits of this.
Yeah, I am taking this. So thank you so much. I will look it up, whether I can find it. But the thing is, after this failure with the new law, they allowed bars or bar associate, like bar, I mean like bar who serves alcohol, those bars to create in-house insurance for themselves so that to reduce the cost, which, as Omri would predict, they regulate the market better and then reduce the risks and safety. If safety is increasable, it may have the best position to increase safety as an insurer because it is the organization of the bars, and they might be the people that can assess the best risk for the safety.
Okay. Do you know if there was any change in the behavior of bars after this litigation explosion or after 2017? Did they have better training for bartenders, or I don't know, breathalyzers when you leave or something? Anything that you can say about what they did or didn't do?
Yeah, from the insurance regulation theory, what they do, they try to price according to those credentials, whether your bartenders take the training, whether how much is your total revenue consists of alcohol. So if your total revenue is 9% drinks and 10% food, then they would increase your premium. But if it is otherwise, then they would reduce your premium, which then it affected the pricing behavior of the restaurants, because then they reduced the food prices and increased the prices just to increase the premium margin on the drink, but reduce and make people sell more food, so that overall it created this balancing effect. But that's what they did. So right now, though, with the new law, if you have mandatory training for your bartenders, the statute requires you to have a lesser limit. That's like for every checkbox you do, they reduce your limit $100,000. So if you are a bar that closes at 12, maybe your expected insurance should be 700,000. But if you have server training, it will be $600,000. But this is a new regulation. It wasn't like that before.
Fascinating. All right. And Frank Chmielewski, if I pronounced that right, had a question in the chat that maybe you want to look at about lawyer advertising in response to any of this.
Was lawyer advertising on drum shop claims, such as billboards, triggered by a new law? So I try to find valid data to test this. I think this would actually enlighten that dark aspect where how the information really worked. But I can't find the information. I try to do searches of lawyer attorney advertisement with the national databases, but there wasn't enough data to figure out what's going on. I mean, I checked different aspects. One funny thing. So I thought that if they are claiming this much of industry impact, I thought that might be an effect of the nightlife activity. So Google Earth has this amazing thing, and free for the academics to test this. It allows you to allows you to differentiate of the activity, nightlife activity before and after. So I did the test phase in like 2016, 2017, did a lot of years, and there's only activity change that the Google Earth machine can trace is when the COVID hits in 2020. At that time, it captures that, but otherwise, it shows a very stable nightlife in South Carolina. Very beautiful beaches. I advise everyone to visit there. It's a pretty state.
Okay, on that note, it looks like it's after 5 when we traditionally end. So please join me in thanking Eserhan. Come back when you have more to report because it sounds like you still have a lot of data to collect and analysis to do. But thank you very much. That was a great talk and paper. Really appreciate it.
Thank you so much for having me. And if you have any suggestions, please out to me.
Great. All right, come back in 2 weeks for another installment, and thanks for coming.